Could you please state your name for the court?
Jesse Rogers.
Thank you.
Your Honor, thank you. Good afternoon. Today, the date and time set for the preliminary exam in this matter. I had an opportunity over the weekend to review the reports. I spoke to Mr. Warren Green. There is a handful of documentations that are alluded to within the report that neither party simply has. I went through it and I'm not sure. It doesn't look like it ever happened. I reached out to the records department of the sheriff's office as well as the OIC, who now is at a different police department. And they're looking into it, but I've not received those documents as of this time. I am unable to adequately perform this exam. And so I'm going to respectfully ask for.
Why weren't, I don't understand.
And Your Honor, our position is I'm asking for a dismissal. When we set this examination, I set it with the understanding that we had everything the people had. And I believe that to be true today. I'm asking for a dismissal because I don't think it's the case that discovery is incomplete. I think the people are simply missing evidence they need to move forward with this case.
Well, which is it? I mean, there are things referred to, what I got out of that was there are things referred to in the report. Do we know whether they exist or don't exist? And if they exist, why haven't they been given to the defense prior to now and certainly prior to the time that this examination was set?
So the report refers to a couple of different items, i.e. a spreadsheet from the University of Michigan Credit Union, as well as a phone call. And it says that the phone call was uploaded to evidence.com. I go to evidence.com, I don't have it. It's just not there. The spreadsheet, there's something that might be the spreadsheet, but I'm not sure if it is the spreadsheet. So there's things that are in the report that I don't feel comfortable. The phone call, I just don't have. The spreadsheet, maybe it's there. I'm not 100% sure that that's a spreadsheet. It doesn't look like a spreadsheet, but.
I don't know what that means. Is it a spreadsheet or isn't it? I mean, if it refers to a particular document, I think you'd be able to try to figure out what it is.
I think if it was copied and pasted from Excel and then into a Word document, it would have just been a formatting error that I wouldn't necessarily be able to make heads or tails of.
And Your Honor, what the defense is in possession of is what purports to be the complainant's banking app records. Those are contained in what is a spreadsheet, and that was produced. What I think the people are missing is Verizon records that are mentioned in the report, but were not produced, are not in the people or the prosecutor's office possession, and certainly haven't been turned over to the defense. I believe we have everything they have.
Why are those records as a proffer necessary for the exam?
The way that I believe that I can prove the case is to show the connection between the defendant and her use of an IP address that comes back to her phone number. And I don't have any of those documentations.
Then how did it get charged?
It's a good question, Your Honor.
Oh, yes, it's a good question. And I don't know whether she's guilty, not guilty. She's presumed to be at this point in time, but she's been going through this process. And you get to the date of a preliminary examination, her first step, and you're telling me you can't show the case and that there's something out there that you don't have, never had, that would link her to this case. So why is she? Going to grant the defendant's motion. This case is dismissed. It is without prejudice. So, ma'am, you need to understand that they can bring the case back, but I'm going to give you fair warning. You bring it back, you better be ready to go. You better have everything that would tie this defendant to this case, or there are really going to be problems. Thank you.
Thanks, Your Honor.
Thank you, Your Honor.
Or it does call the case People versus Dylan Chapman.
Your Honor, Alexis Blumey, Assistant Public Defender, appearing with and on behalf of Mr. Chapman. Mr. Chapman, could you state your name for the record?
Dylan Chapman.
Thank you.
And Your Honor, today is the date set for preliminary examination. I understand there is a bond violation. However, also at this time, people are unable to proceed as to counts 1, 2, 3, 4, and 5, and would ask for counts 6 and 7 to be remanded down to district court.
So you're unable to proceed on 1 through 5
Correct.
and would like 6 and 7 down. Got it.
Correct.
Counsel, you're moving to dismiss counts 1 through 5.
Yes, Your Honor.
Continue to defendants not guilty, plea yes to count 6 and 7. Set this matter for pretrial.
January 29th at 10:30 for Judge Simpson.
That date might change. There's an in custody thing. We'll see, but you got the 29th right now, correct?
Yeah.
Got it. What time? 9?
10:30.
10:30. Before Judge Fresh Hour. As to the bond violation.
Yes, Your Honor, I have had an opportunity to discuss the violation with my client. He has provided me with an explanation that he feels comfortable with me sharing with the court. This was reported as a hit and run accident. Mr. Chapman states that the complainant in this case was using his car, which she had reached out to his mother and asked if she could borrow because hers was either broken or not able to drive in the snow. He states his mother gave her the keys to the car and allowed her to use it. And then Mr. Chapman states that at some point that night, his mother called him and let him know that the complainant had been involved in a hit and run accident with his car. He tells me that he did go to the scene of the accident to try to check on his vehicle, and that at that point, the complainant was not actually present. It's unclear to me in the report at what point in time the police made contact with the complainant because it was a hit and run accident. I'm not sure if contact was made at the scene or later on, and there's not a whole lot of detail there. So Mr. Chapman is asking that the court consider keeping his personal recognizance bond in place, given that explanation, and potentially setting for a pretrial and bond violation combination in front of Judge Fresh Hour, so that if there is more detail that needs to be provided, Judge Fresh Hour could consider that.
Your Honor, at this point, I have concerns given the nature of that bond violation with his wallet, his other property being in the car. He's not there. I would have concerns about contact with the victim, being there with her, especially given the nature of the charges. So at this point, I would ask that he be remanded on the bond violation.
Your Honor, again, the only thing I will add is that Mr. Chapman explained to me that his wallet and other items were in the car when his mother provided the car to the complainant. So again, he's just asking that the court consider. Yes, Your Honor.
That his wallet, ID, and all of his everything is still in his car.
Yes, Your Honor.
Clean sheet.
My understanding is that the car was supposed to be returned to his mother soon thereafter, and that Mr. Chapman said it was okay to leave his wallet in that case the complainant needed to use his debit or credit cards.
So how close was he when this vehicle crashed? Because they have him one driveway over.
Yes, so Your Honor, he states he did go to the scene of the accident after his mother told him that there was a hit and run crash to check on his vehicle. However, it's unclear to me in the report, and based on what Mr. Chapman is telling me, at that point in time, the accident had already happened and the complainant was no longer there, and he was just going to check on his car. So again, I'm not sure because it's unclear in the
How
report
do I
whether
know the complainant's not there if she had the car? From this defendant?
so the complainant's not
Hmm?
at the scene of the accident.
Yeah.
Right. We don't know. And I'm saying that it's unclear to me when contact was made with the complainant, at what point in time.
I hear you, but none of that makes any sense to me because it almost seems like he's with the complainant. The vehicle crashes, she leaves, and he's still there. That's why the only thing that makes sense as to why his wallet, ID, all of that stuff is still there because he was in that vehicle when it crashed.
And that is not the explanation that he is providing.
I get that.
Yeah.
But none of the other part makes sense. I'm not. Anything else?
No, Your Honor.
I think when I look at everything that the defendant was having contact with the victim in violation of the bond conditions in this case, and based upon what was said, at this time, I will move his pretrial date up to January 15th, 2026. That's still at 10:30.
Yeah.
January 15th, 10:30. But at this time, the court's going to believe that there's enough evidence and to indicate that there's been a bond violation. I'm revoking the defendant's bond. The defendant is remanded.
You're gonna let me talk. Okay, hold on.
I don't really, I mean, at this point in time, it don't matter anymore. It doesn't matter anymore. You made your decision and it
Yeah.
doesn't matter. You just ruined my life. I was starting to do good. I had a good job. I had a good support system behind me and all that is gone now. Not mercy to me and me failing, like that was, I still hold that as a reminder in my head today that, I don't want you to think that your mercy was extended in vain. I'm just grateful for your time today and I do take accountability and I accept whatever punishment you see fit.
They were not gonna get caught. Well, you made it about a year, picked up a retail fraud, and 8 of 15. Then for 9 of 15, you were back in trouble about a year later. Then, while that case was pending, you picked up another charge in Benzie County. And this was a set of felony charges. You had multiple probation violations there. Number 11 of 15, you violated bond again and picked up an aggravated assault. Number 12 of 15, this is where you picked up other charges while violating probation. In fact, you violated probation for use of meth. You did have about a 3-year gap until you picked up another set of charges, and that was just a jostling. But your probation was terminated unsuccessful in that jostling case. Why? Because 3 months into that probation, you picked up a home invasion, which was apparently pled down to a domestic violence. So you got repetitive acts of violence in your history. Looks like you made it about a little over a year before you picked up this case. And as we know, on it, you violated bond and picked up new charges. So definitely established a pattern to support the court with reasonable grounds. Now, it's not so much about, as I mentioned earlier, not about me as a judge, but when the court allows somebody to go to rehab, it does so because it cares and wants to give rehab, but I also do it to see how people behave and whether or not they're going to continue their previous patterns. So that's a problem. So what I see here is 20 years of the same types of almost 20 years of the same kinds of problems: violating bond, violating probation, acts involving drugs, acts involving crimes of dishonesty, acts involving violence. And The point here is it's not whether or not I give you the grace or this court gives you the grace. It's not because you've had lots of opportunities over several years of grace and opportunities, probation, and so forth. Now up to you to decide if you are going to take advantage of those opportunities and the benefits given to you.
Absolutely.
All right. The sentence in this case court is as follows. 1 second. I want to look up something. Also in the past, I see on that morphine case, which also had a tribal license suspended, 270 days. That was the end sentence after 110 initially, but after the probation violations. And then for the fentanyl case in 2016, my predecessor gave you 120 days only. So now I'm starting to look now I'm starting to look and say, when I look at your prior confinement periods, the question is has it been working? Well, in this case, the court assesses the standard $68 state minimum fee, $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. DNA was already available. There will not be any supervision. So there's no supervision fees. The court sentences the defendant to a jail term at the top of the guidelines, which is 330 days with 35 days of credit. I do so because I've already covered all the reasonable grounds. Every opportunity or grace has been provided to you, and you've thwarted them over and over and over again. So, no, it's all right. That's the sentence. There's nothing you're going to say that's going to make it better.
Just no treatment, but another to continue to stronghold my treatment.
Yeah, well, they have people who come to the jail. You're not going to be placed on probation. You're telling, just as Mr. Nago said, you're at that level where next time you're looking at presumptive prison cells on felonies, at least for drug charges. And you've had the opportunities and you rejected them. And it's your issue, not mine. It has nothing to do with this court. That's the sentence of the court. Have I missed anything, Mr. Blazak?
Is there any way I can get work release?
I don't believe so, Your Honor.
Mr. Denon? Madam Clerk is going to bring out to you, ma'am, 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the copy of the document. This document tells you that you have the right to file an appeal in your case. Based upon the plea, any appeal must be done by filing an application for leave to appeal and not a claim of appeal by right. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Any questions, Mr. Niegos?
I got it.
All right. Thank you all very much. Ms. Sims, I do want you to use your time effectively. I'm hoping that the words I choose, not that everybody pays attention to them, sink in. You're at that level now where there is nobody else.
Tramadol.
I'm sorry?
It just upsets me because it's for my dead dog's tramadol. I'm getting county in.
No, hold on.
Yes,
You're not.
that's what's upsetting.
Just a second.
I didn't even have it in my possession. And because of my past history from 12 plus years ago. That's what's upsetting.
Yeah.
I'm losing my job. I'm gonna lose everything
Because of what?
because of my past history.
Yeah.
People change, Your Honor, and I have changed. In past history, the fentanyl charge wasn't even a fentanyl charge. I got larceny in a building.
Okay.
This is for past history, and I had my dead dog's tramadol. I don't even know how it's illegal for me to have a prescription of my dead dogs anyways. This whole thing makes no sense to me. I'm just in shock right now.
Okay. I understand that you're just in shock, but this is not just because of your past history. This is because your pattern And because in your pattern, you continue to demonstrate, you continue to violate bond, you continue to violate
Give
all,
somebody a county year.
you're gonna let me talk. Okay, hold on.
I don't really, I mean, at this point in time, it don't matter anymore. It doesn't matter anymore. You made your decision and it
Yeah.
doesn't matter. You just ruined my life. I was starting to do good. I was starting to have a good job. I had a good support system behind me and all that is gone now. So it was like, what was the point? What was the point of me trying to change? This is why people don't change, because when they do, things like this happen.
We're very calm today, which is something I'm working on. Every judge has to work on it, and that's okay. If you want to blame me, Ms. Sims, that is perfectly okay. It's directed in the wrong direction. No, no, stop.
You don't care, I know.
Okay.
Can we please go?
You may leave because I'm about to add 60 more days to your sentence.